regarding the Employees Provident Fund Act 1991. Okay, if you see the screen here, it's regarding matrimonial assets claim. Okay, it's provided under Section 53A of the Employees Provident Fund. So there is a circular by the Bar Council to all lawyers, okay, and on those who do family matters. So highlight some of the things that the practitioners should know when you are filing your claim against your ex-spouse for the matrimonial assets. Okay, this is particularly regarding the withdrawal part, okay, because if you are claiming matrimonial assets as part of your assets, okay, in a divorce to be distributed to the claimant, I mean, if it's the wife who is claiming against the husband's EPF, then he has to follow some of the procedures, okay, laid down under the Act to order to claim, and also the terms and conditions of the Employees Provident Fund, okay, of the KWSP, in order to claim that money. So EPF highlight there are things that you need to know when it comes to a claim by claimant. Okay, when you want to withdraw your ex-spouse EPF account, which is regarded as matrimonial asset. Okay, for general rule, EPF account is not, okay, a matrimonial asset unless and until the court declares that it is. That means you have to apply to be declared as a matrimonial asset. So it's not an automatically declared as matrimonial asset. Okay, so EPF transfer the monies upon receipt of the sealed court order. Okay, once the court order, where the court order for divorce, and then they will serve it to the EPF if you are claiming for the asset. Okay, the EPF account is part of the matrimonial asset. So EPF will transfer the money upon receipt of the sealed court order. Okay, next slide. Okay, then the transfer of monies from the ex-spouse EPF account to the recipient is the one who claim. Okay, if the wife is claiming, the wife is claiming as recipient. So it will be credited to the recipient's account, the wife's account. Okay, is subject to the amount of monies available in the ex-spouse EPF account. That means if the wife is claiming from the husband's EPF account, the monies in the EPF account. Okay, if let's say he's claiming for 100K, okay, from the ex-spouse EPF account, but in the ex-spouse EPF account only got 80K. The balance is only 80K, so the EPF can only transfer 80K and not the 100K as claimed by the recipient. Okay, so it's subject to monies available in the account. So despite money, okay, this one number 3 also very important. Despite the money being transferred, after let's say the EPF transfer, it doesn't mean that the wife, the recipient, can withdraw immediately. So he still cannot withdraw. He can only see that he's being credited, but he cannot withdraw the amount from the EPF until the events occurred under the EPF Act. Okay, so if you see the blasting, the SharePoint highlights that you have blasted to you earlier. One of the events is until you reach 55 years old, if the recipient is dead, okay, and then I mean the next of kin, okay, or the executor will withdraw, and that one only upon these events then you can withdraw the money. Yeah, okay, unless if not, then you have to wait until 55 years old to withdraw that amount. Okay, so you cannot immediately withdraw. So some of the events, I can't remember, one of it is upon the death of the recipient. That means the executor or the administrator will withdraw, and then, or if not, you have to reach 55 years old, and there are the 2 more conditions there. Okay, so if you fulfill any one of these conditions, then only you can withdraw the amount from the EPF. Okay, and also under the circular, EPF also gives some example of terms of divorce that which they cannot carry out. Okay, so it was suggested by EPF that when you draft the terms of divorce, make sure that it is terms that can be carried out. Let's say if you put just how many percent, okay? Or you don't put a time frame, or you don't put is something so general that it's not specific enough that EPF cannot execute or cannot carry out the instruction. Okay, so if they cannot carry out, they won't carry out. So if there's any issue, you have either, the lawyers have either to go back to the court to amend, to vary the court order, to vary the decree, then only you get the EPF to withdraw that money. So when it comes to terms of divorce, okay, especially the withdrawal of the amount, it must be very specific. Okay, either the amount, the date, until when, what, all this have to be specifically pleaded. Okay, for more details, you can see the circular. Okay, the full circular is quite short, I mean 2 to 3 pages if I remember. Okay, so you can click back, always just click back to the circular to see the full circular lah. Okay, next slide. Okay, before that, is there any question on the EPF part or the matrimonial asset part?
No.
Okay, if no, then this one is more to okay, because I share not only everything must be legal, so this one is some general knowledge. Okay, why I put this stomach rubbing exercise, because I do it myself almost every day right after I open up my eyes, okay, after waking up, then we do this in the bed, okay, on the bed. So this also part of it. Okay, it's not so much to getting rid of belly fat, but it's just to exercise to for constipation problem. So this is a very good exercise for that. Okay, I mean especially for me lah, from my experience lah. Okay, so yeah, what is that? Ivan, you're saying something, Ivan? Are you saying something, Ivan?
Yeah, show us how it's done.
I cannot show lah.
Why cannot? Just stand up, go behind, put your laptop far away and do it lah.
Ayo. Very simple ni lah. Okay. Okay. Get it? Okay. Okay. So this I already explained why we are doing that. Okay. Just not to getting rid of belly fat, also for health lah. Okay. Okay. Next slide. How to do? Okay. Begin by lying down on your bed. Okay, on your back. Okay, you sleep flat. Then relax. Put the palm of your hand on your navel. Like that lah, like that. Okay. So when you're sleeping, you start from here is the navel. So you start from here, clockwise, clockwise. Okay, from your right to your left, like that. Okay, you can put, I put minimum 30 times, okay, 30 rounds. You can put as many rounds as you want. Okay, and then I put 30. After that, circle the bigger circles. Start from here, then here, circle, bigger circle. The whole stomach there. Okay, you don't have to press down hard. You just a little bit of pressure only lah. Okay, and slow, don't fast. Got it, Ivan? Ivan, you want to demonstrate? Okay, so you gradually expand. Okay, so this is, you start with clockwise lah. Clockwise. After that, you finish your 30 rounds and then another 30 rounds, okay, for a bigger circle. Then after that, you started counterclockwise. That means from your left to right. Okay. I do a little bit different here because I will, from counterclockwise, I do from navel, then only to the bigger circle, okay, counterclockwise. So in the blasting, we explain why we do clockwise, why we turn clockwise, and why we turn counterclockwise. Okay. So you turn clockwise is to make the stools one way is to make the stool loose, and one way is to make the stool solid. Okay, so that's how you need to balance it lah. Okay, so so far it has worked. So far so good for me. Okay, so you can start it. Okay, if you want to try. Okay, but if you have any condition, please, okay, you can consult a doctor first. Okay, so I'm not a doctor, so just from my experience only lah. Okay, next slide. Okay, this one another SharePoint highlights. This one is about the car insurance. Okay, if you are involved in an accident, okay, you want to that your car is damaged, and then you want to claim from not your own car insurer, but you want to claim for the other party, the party who run to your car, who knock down your car, their insurer. So how you want to claim from them, okay, to satisfy the judgment sum. If you file a court judgment, okay, file a court suit, okay, after you got judgment, you want the insurer of that party to pay the sum. Okay, so how you do it lah. Okay, there's this one reminder that you have to notify the car insurer, because when your summons, when you file your summons, you normally don't name the car insurer. You name the driver and the owner who knocked down the car. Okay, but when payment that time, you know, the car, this car driver may not have the money to pay the claim. Okay, you usually say claim from my insurer. So how you get the other party's insurer to pay, then you will have to first notify. Okay, next slide. Next slide. Okay. Okay. So the insurance party is usually not named in the action. Why is not named? Because he's not personally liable. The liable, the rundown, knock down your car is the driver, okay, the owner, not the insurer. Okay, so but insurer is the pay. Okay, so if you intend to get the party insurer to pay the judgment sum in the event you win the claim, okay, you need to notify the insurance company of the court proceedings. When you need to notify, not only after you get the judgment, that's too late already, because it's provided under section 96(1) of the Road Transport Act. An insurer has a duty to they have a duty to satisfy, but you need to comply, okay, against the insured in respect of claims by third party. Means third party is the claimant who claim against the insured, the one that the car insurer has insured. Okay, next slide. So the insurer may not pay if it was not notified of the legal action before or within 7 days. So when you need to notify, if the one filing the summons to claim against the other party who knocked him, okay, he must serve the summons on the insurer of that other party, either before 7 days, before he filed the claim, or within 7 days he filed the claim. Okay, if you serve only late, they may have an excuse. You say, I'm not going to pay because you served me out of time. Okay, so who are supposed to inform? Who's supposed to notify this insurer? Don't wait until the insured, okay, the other party, to inform his own insurer. Okay, you want to claim from the insurer, then you have to inform the insurer. You have to notify. Okay, just a simple letter to serve that summons, okay, on the insurer, or a simple letter to say that there's we were giving you notice, okay, that we're claiming this sum from you, okay, and then if you have got the summons, then you serve a copy of the summons to the insurer, okay. So the duties on the claimant, okay, who files the action. Okay, next slide. Okay, this one is another highlight. Just want to share this. Okay, this one regarding land acquisition. Okay, land acquisition, we know as a general principle, the acquiring authority usually is the land office or the state government or the federal government. They compulsory acquire, that means they will just take by force. Okay, you have no chance to argue whether it's can take or cannot take. You can only argue usually is on compensation part. Okay, so there is a principle that they have to compensate, okay, for the property that they take away from you. Okay, so in this case, okay, there's this question whether they still need to compensate the management corporation, okay, for acquiring common property. This one is after they have already paid the parcel owners. So what happened in this case is that the acquiring authority, which is the land office, they acquire a strata development. Okay, so strata development, there are, as you know, there are properties there, units there, and also common property. So they already paid for they compensate the unit owners already, okay, for the units they acquire. But for the common property they acquire, they say no need to pay. They say they don't have to pay the management corporation because common property is under the management corporation, right? So they give reasons lah, okay? For their reasons for not paying is there are a few reasons there. Okay, next slide. Okay, so the land administrator's position is that no need to pay compensation for acquisition of common property, while the management corporation's position is that you need to pay, okay, for acquisition of common property. Sorry. So land administrator's position, next slide. Okay, one, the strata development is very old, okay, is condemned as unsafe. So an old development, an unsafe development, therefore would have very minimal market value or no value, okay? So no need to compensate. You can just take away the unsafe building. So court disagree with this, with the land administrators, because he say if your position is correct, okay, not only the common property is old, that means the units are also old, right? So by right, the parcel units also, they also won't get any compensation, right? Okay, so but in this case, they compensate the parcel owners, but they did not compensate the management corporation. So the court finds that the position of this land administrator by arguing this is very opposite of what a willing buyer and willing seller will do. Okay, so in normal willing buyer and willing seller, okay, Mike, next. No. Next, before that, yes. Next slide. Oh, okay, there's actually one more here. Okay, before that, go back to the, okay, here, actually I missed out something. That means, why is it the opposite of a willing buyer and willing seller? Is that a willing buyer will usually, in a normal case, they'll usually value the land more than value the building on the land. Because in the case of land acquisition, they will usually destroy the everything and then build up a new building there, or redevelop the land. So the value is on the land, not on the building. Okay, so that's the whole purpose of the acquisition, because they would redevelop, they would destroy everything on the land and then redevelop a new one. So the land still fetch a value, no matter how old is the land, because it's still capable of being redeveloped. Okay, so by arguing, if they agree with the land administrator, then the land administrator's position is the opposite. It means you are putting more value on the building rather than on the land, which is not correct, which is not what a normal willing buyer and willing seller perception will do. Okay, so the court disagree with this proposition lah. Okay, the next proposition, mine. Okay, the second argument of the land administrator is that the common property has no value because it's not transferable. Why is it not transferable here? Because section 57 says because you have not terminated, you have not cancelled the subdivision. So it's not transferable for the moment until you cancel the subdivision, then only you can transfer. But the court disagreed because it's incorrect to say that the common property is perpetually non-transferable, because it's only non-transferable for that moment because the subdivision is still there. Okay, the subdivision is only cancelled until when the units there, the strata units there are destroyed, totally destroyed, then only the subdivision is cancelled under section 57 of the Strata Titles Act. Okay, so it is not perpetually non-transferable. So once this subdivision is cancelled, it will become transferable. Okay, so even if the court say, even if it is perpetually non-transferable, it does not mean that that common property has no value. If a property is perpetually non-transferable, okay, you cannot say it has no value. You can at the most say that it has a lower value than normal property, lower value, but it still has value. Okay, you cannot say that its value is zero. Okay, next slide. The third proposition, the land administrator say the value of the common property has already included in the compensation paid to the parcel owners. So the court disagree also, because even if the land administrator is correct to say that the value of the common property has been included in the compensation to the parcel owners, the acquiring authority still responsible to pay back to the rightful owner. Okay, in the first place, I also see this proposition as very strange, because on one hand you say there's no value, on the other hand you say there's value has already been included. So your position is you got value or no value. Okay, so if it says in being included in the compensation paid to the parcel owners, also not correct, because these parcel owners are not the rightful owner to be paid this value of common property, because this common property belongs to the management corporation. It doesn't belong to the parcel owners. Okay, so either way he argued this, okay, he couldn't get it because the court will disagree. All right, okay, next slide. Okay, so the court couldn't agree with all the proposition by the land administrator. Okay, and he looked at the court also have to consider, because in the land acquisition matter, you have to, the court left and right will have the assessor. Okay, on his right will have the government assessor, on his left will sit the private assessor. There will be two assessors usually, will assist him in coming out with a reasonable compensation that he will declare. Okay, he will pronounce it to the applicant. Okay, so the government assessor, he maintained his position. Okay, he agreed with the land administrator. He said that after reading the submission of both parties, he still feel that no compensation should be paid. That is his opinion lah. Okay, for the private assessor on his left, he said he initially said no compensation to be paid to the management corporation. But after reading the submission of both parties, he revised his opinion. So he said that compensation should be paid for acquisitions of here, because here I need to explain a bit. The common property that the land office take away consists of empty land, okay, and also car park base. Okay, here so government assessor said no compensation at all, even for parking, even for car parking, even for empty land. But for private assessor, he said empty land and open spaces may not, okay, you may not have compensation, but for car parking base, some reasonable compensation ought to be paid lah. Okay, so his reason is that parking base there's nothing to stop the management corporation from imposing parking fees. Okay, so even though in this case it's used free of charge, there's no parking base, but it doesn't mean that they cannot charge parking base. Okay, so you have to, when you calculate the reasonable compensation, you have to include that, okay, the value, if the possible losses, if they impose car parking fees. Okay, so that's why for empty land, it's already been used there by the residents there. Okay, so there's no additional value, because he said, okay, since the land administrator said he's already included that value, so if you include this one against, that it will be double counting, okay, according to the private assessor. But for car parking base, he says some reasonable compensation ought to be given. So that is the opinion of the assessors. So the court, next slide. So the court agreed with the opinion of the private assessor. Okay, so what the court held, that no compensation for open space and empty land, but reasonable compensation to be given for acquisition of car parking base. Okay, because some of the parking base, if I'm not mistaken, just now I read, is some of it they charge, some of it they don't charge. Okay, some of it is free of charge, some of it is charged. But in calculating compensation, they should, for car parking base, they would give some compensation as well for the loss of use. Okay, the loss of income. The award of the land administrator be increased, okay, by 685,000, and interest. Okay, normally it comes with interest from Borang K until the date of full payment. So other items in the reward remain unchanged, and the cost of land reference to be borne by the land administrator. Okay, so this I would say this case is okay, slightly open for general. It's not really general principle, because general principle, yes, it would have to, but it will still see a case-to-case basis. Okay, it will depend on what is being acquired, what the acquired property comprise of. Okay, is parking base or open land or empty land. Okay, that will have to be taken into account. Okay, so is there any question? I think that slide don't have ready. Okay. Any question? Okay, if not, then I shall end the SharePoint highlights. Okay, feel free to ask me any question if you think of any later. Okay, thank you. Have a nice day.
Okay, thank you.